Is your business protected against the threat of malicious litigation and frivolous lawsuits? Are you sinking company profits into marketing campaigns that do nothing to contribute to the growth of your business? Bottled Business Sense provides practical business perspectives that uniquely emphasize both legal and media marketing strategies to protect and ensure the longevity of your business. And whether you're trying to provide a startup business with some level of stability or an established business with foolproof asset and estate protection, or simply attempting to get a better return for your business marketing dollars, Bill Bernard and Rick Moscoso will expose potential pitfalls to ensure the security and growth of your business, free from unwanted expense and the threat of litigation. You'll learn how to implement marketing and protection tools equal to those used by today's most successful corporations. Let's join Bill and Rick for today's Bottled Business Sense show.
Well, welcome everybody.
Good morning. Good morning, everybody. We're long distance here. Again, I'm out of town on business, so Rick and I might stumble on each other. But good morning, Rick. My co-host, Rick Moscoso, is in Southern California. I'm out of town on business. I'm Bill Bernard, and we're here for another Bottled Business Sense show. How are you, Rick?
Hey, Bill. I'm doing great. Sorry for stepping on you on the intro here, but
no problem.
But yeah, I'm excited to be here. I know. You're excited to talk about the topic that you're going to be talking about today. But before we get into that, I want to welcome our viewers and our listeners out there. If you are a first-time listener or viewer of the Bottled Business Sense show, welcome. We are here every Tuesday at 10 a.m. Pacific time talking about business and legal and marketing subjects. And you guys are all welcome to provide feedback, to provide topics that we can talk about in the future. If you're interested in doing that, come by and visit us on our website at bottledbusinesssenseshow.com. You can also send in comments and requests for sponsorship or future topics at bottledbusinesssenseshow@gmail.com. So with that being said, before we get started, Bill, how are you doing?
I'm doing okay. Out here trying to get some work done out of town, and that's always difficult. Keeping in touch with the family and keeping a thumb on everything, and making sure everything runs smoothly. But that's part of the challenge of my business. I enjoy it. And I would not go out of town without putting on my priority list of getting another Bottled Business Sense show done, because we're really here for the viewers and the listeners, and we want to help their business grow, and we want to help it prosper and be stabilized. So it's definitely right up there on my priority list with all the other things that I do. So today I want to just mention to everyone that this is going to be a follow-up from our August 5th show, because we got some very interesting questions and some requests to follow up on that show. You might remember that was the Estate Asset Protection Combo show, where we talked about protecting both business assets and estate assets in a very unique way. And so we got some questions about beneficiaries. Okay, so now these assets are going to be protected. What about the beneficiaries? Some of the uniqueness, some of the unique opportunities that beneficiaries of this asset protection trust that we spoke about on August 5th. How do they fit in, and how do they come out of this on top of the game? So that's what we're really going to talk a little bit about today, and it's going to be the show is really entitled Beneficiary Creditor Protection. So, having said that, let's talk about some of the basic structures, lay a little bit of the foundation that we're going to talk about, Rick. And I just want to make sure that all of our viewers understand that we've had a lot of phone calls, a lot of feedback, some questions concerning our show on August 5th, which was the show you might recall being the Estate Asset Protection Combo. We uniquely talked about domestic asset protection trusts and how you can combine business assets and personal assets and ensure that they're protected. We had some questions, interesting questions, asking for some more information on this topic. So I thought I would follow this August 5th show up with a show involving beneficiaries specifically. And so this show will be entitled Beneficiary Creditor Protection. How do the beneficiaries of this trust, the people that are going to receive the assets from the trust, what's their protection status in a little more detail, and how is that affected once the settlors, the creators of the trust, pass? So that's what we're going to talk about today, Rick.
All right. Well, great. I'm excited to hear about this because I know that you have the unique skill of taking complex things that the layperson doesn't tend to understand in great detail and make it understandable for folks like myself who's not doesn't understand legalese. So I'm excited to hear this because I know I'm going to learn a lot from it. So as well as our viewers out there. So
well, good.
So thank you for that.
No problem. Thank you, Rick. I appreciate those kind words, and you're much too kind. And by the way, before we do get started, all of this magic that you see, and it's magic to me, folks, this long distance way of being able to do our simulcast, this is all the magic of Rick Moscoso and R2 Visual Studios. So you are seeing what he can do here on this show, and he can certainly do the same thing for your business. So anyway, let's recap a little bit about what we were last talking about on August the 5th, and that was some background I think that would be pertinent for the show is the fact that usually the only way trust assets, that's things that you put into your trust, normally the only way they could be protected from creditors in terms of the creator of the trust, the settlor, was to give up complete control for all the benefits of the trust. So I'm the settlor. I'm the person that's going to create the trust. Excuse me. Normally, the only way I can be protected is if I give up all of my benefits. That is, I make an irrevocable trust, one that I can't change. That means I don't serve as the trustee of the trust. I can't amend the trust. I can't receive distributions from the trust. I can't derive any benefit from the trust whatsoever. That's the way normally you can protect your assets by way of this asset protection trust. Traditionally, asset protection is always afforded to the beneficiaries of a trust through what's commonly called a spendthrift provision, which means that creditors can't go after what a beneficiary receives from a trust upon the passing of the settlor. That's a traditional spendthrift provision, and that's normally included in most trusts. Okay? However, as I just stated, if you are a settlor of a trust, if you're the creator of a trust, you will not have the benefit of that spendthrift provision because you normally won't receive distributions from that trust unless you decide, hey, let me make an irrevocable trust, let me make a domestic asset protection trust. Now, is there a way for me to be protected from creditors? Is there a way for me to receive benefits from this trust that I normally couldn't receive? Is there a way for me to still be a trustee of this trust, which normally I could never do under an irrevocable trust scenario? Is there a way for me to have some control over these assets just like a normal beneficiary?
Clarify this for me for a second.
Sure.
As the settlor, are creating the trust, okay, that from what I understand, is that you as the attorney, or is that me as the one that is benefiting from the trust?
No, the settlor, or another word for the settlor would be trustor, Trustor. That's the person creating the trust. It has nothing to do with being an attorney. An attorney will set up the trust, and he will say who the trustor or settlor is going to be, and he will also say who the trustee is going to be according to the wishes of the trustor, the person creating the trust.
Okay.
So remember that the trustor, or another name for the trustor is settlor, though that's the individual creating the trust. The trustee is the individual running the trust, has the responsibility of running the trust. Many times, a trustee and a trustor can be the same person, where you have a revocable trust. Where you have an irrevocable trust, one that you can't change, historically, the settlor or trustor could not also be the trustee. However, under the domestic asset protection trust scenario that we talked about on August 5th and that we're now talking about today, you can be the trustor and the trustee and have the same benefits to some extent as the beneficiaries have. Okay? So it's a very complex issue, and I want to make sure that that people understand it. When you make a trust, you have beneficiaries, and those beneficiaries have they receive benefits. That's why they're called beneficiaries. They receive benefits from the trust when you pass. Normally, where you have a trust that you can revoke during your lifetime, you, as the trustor, the creator of the trust, can also receive benefits. When you have an irrevocable trust, one that you can't change during your lifetime, normally the trustor doesn't receive the benefits that the beneficiaries will receive. However, under the asset protection trust scenario, the trustor of the trust comes more up to the level of the beneficiaries and can now receive some of the same benefits that the beneficiaries will receive.
So what kind of benefits are you talking about?
Well, that's what we're going to talk about right now. Let's talk about some of them. Creditor protection, is one of those benefits. An asset protection trust, again, is a trust that protects the trust assets from creditors and liabilities, of the beneficiaries. As long as the assets are in the trust, they do not belong to the beneficiaries, and they're not subject to the beneficiaries' debts. But what happens when the settlor or trustor passes and the beneficiaries now receive these assets? What happens? Are those assets going to be subject to claims by creditors for any debts that the beneficiaries might have? So, Rick, you're the beneficiary of my irrevocable trust, my asset protection trust, and I'm leaving, let's say 50% of my estate to you. But you decide you're going to run up some heavy debt. You take your credit card and you go out and you just have a blast at Macy's and at the Nordstrom's, and you're buying all this beautiful stuff for your wife, and all of a sudden you have $75,000 in debt. Are the creditors going to be able to come after you and satisfy that debt based on the assets that you receive from my domestic asset protection trust? Well, the answer is, unless I make a conveyance to the trust which is fraudulent, whatever you receive from my trust is going to be creditor protected. You're going to be a beneficiary who has the protection of my assets that are coming to you by way of the trust, as long as I did not intend to hinder, delay, or defraud any of the creditors at the time I transferred the assets into the trust. You would not only be protected from the assets that you received, but I, as a settlor, while I was still living, would be protected if I received any benefits from that trust during the course of my lifetime, as long as I didn't do it, transfer it into the trust with the intent to defraud.
Okay, so give us an example where someone that would benefit from this would be liable for defrauding the trust.
Okay, well, if I now remember, again, to make sure we're on the same stage here, in a domestic asset protection trust scenario, I can receive benefits from the trust the same way that a beneficiary can receive benefits, I can receive those benefits during the course of my lifetime. Okay? Normally, without the protection of a domestic asset protection trust, I would not be able to do that. Okay? So, I received some benefits from the trust during the course of my lifetime, and I have some creditor debts. Those debts would be protected from the assets that I received would be protected from creditors as long as I transferred those assets into my trust without the intent to defraud. So, and this goes back to the principle that I've always told people to prepare ahead. Transfer assets into your trust periodically. Do it over the course of time. Don't do it while there's any pending litigation. Don't do it while there's even a potential claim out there against you. Do it before any of this happens, because the courts may come after you and try to accuse you of transferring assets into the trust to protect yourself from a claim by a creditor. And if the court is successful, if someone is successful through the courts in doing that, the trust can be pierced and the assets can be attached to satisfy the debt. So essentially, what we're saying here is, I don't have any debt. I transfer a lot of property and a lot of funds into my domestic asset protection trust. A year down the road, I incur some debts. Okay, those debts cannot attack my assets in the domestic asset protection trust to satisfy any of those creditor debts, because at the time I transferred my assets into the trust, I did not owe any money to that particular creditor or creditors. Therefore, there couldn't have been any intent to hinder, delay, or defraud them. So therefore, I could not have those assets reached to satisfy those debts. If, on the other hand, I moved those assets into my trust after I incurred these debts, it could potentially be inferred that I did so in an effort to protect them, so they couldn't be used to satisfy the debts of the creditors.
So why isn't it then most people don't do this, use this as a standard practice?
Well, that's a $6 million question. Why do people buy big screen TVs instead of going down and getting a trust package, or instead of getting an LLC and protecting their business? That's an age-old question, Rick. People either don't find this something that is interesting to them by way of, remember we talked about in one of our first shows, what people normally will satisfy the things that they want and get the things that they want as opposed to the things that they need.
Right.
It's just like, why don't you go down and get an oil change every 3,000 miles so you don't have your car blow up after 100,000 miles and have to get a new engine, right?
Mm-hmm.
I mean, it's preventative maintenance, and people sometimes don't do it. But at the end of the show, I'm going to recap this a little bit, and I'm going to tell you what type of people normally do go after this kind of a trust, and maybe that'll help narrow down for people as to what some of the criteria might be if in fact you are interested and you want to consider this type of a trust.
All right.
But
Okay.
let's do our first commercial break, if we could, Rick, right now, and then I'll get into some of the other powers and benefits that you have as a settlor or beneficiary of this type of a trust.
Well, excellent. Well, today's episode, we are excited to announce one of our newer sponsors, and that's Gateway Business Solutions. And their goal is to grow and protect your business through service professionals, and that would include an accountant, an attorney, insurance, both on the commercial and health side, and also a business coach. And if you take a look at Gateway, that's GAITEWAY. That basically stands for growth and development, asset and estate protection, insurance coverage, tax and accounting services, and employer and employee benefits, and that's Gateway. And Bill has helped begin this organization not too long ago. I think you guys have been around for, 18 months, 2 years?
Yeah, about 2 years now. And we picked the phrase gateway because it was supposed to stand for gateway. The G is for growth, the I is for insurance protection, and that would include both commercial and health insurance. And the A is for asset protection, the T is for taxes, and the E is for employee benefits. So that's how we came up with the phrase gateway. And it's a one-stop shop, essentially, Rick, for people to come and get what they need for their business without having to go around and try to vet each individual in each profession.
Yeah, exactly. And it's basically a business solution where you can find everything you need to run a growing and profitable business. Right, Bill?
That's exactly right.
Yeah.
And where can they can find us on LinkedIn and Facebook, and we even have a website.
Yeah, you can find them on social media, or their website is gateway.net. That's GAITEWAY.net. Or you can contact them directly at 949-698-6222, and that's Gateway Business Solutions.
Good.
Okay, let's
get back to the show. And here we're going to talk about now are the kind of powers or benefits that the settlor, the trustor, the creator of this trust, in other words, can have. Because remember, at the top of the show, I said if you had a revocable trust, one that you could change during the course of your lifetime, the settlor didn't normally have any of these powers. Did always have these powers, but once he made an irrevocable trust, one that you can't revoke during the course of your lifetime, he then didn't have any of the same benefits from the protection of creditors standpoint and others that the beneficiaries would normally have, right? So now we're going to look at, now we have a domestic asset protection trust. It's irrevocable, can't revoke it. How do we raise the bar for the settlor or the trustor to enable him to have the kind of benefits that he would normally not have when he makes an irrevocable trust? So, to obtain creditor protection and to have some of these powers, you create your domestic asset protection trust. And one of the powers that the settlor can now have is the power of appointment. Here's what I mean by that. So that's number one, power of appointment. Traditionally, in order for the settlor to receive asset protection, it meant that the trust, once the trust was established, he could not affect any distributions of the trust, right? Later, if he changed his mind about distributions, he couldn't make any changes because it was an irrevocable trust. Once he did the trust, that was it. It couldn't be changed. Now with the domestic asset protection trust, the settlor, a trustor, a creator of the trust, in other words, can retain the ability to change where assets are distributed. In other words, he can retain a power of appointment that allows him to change who the final beneficiaries are. So, Rick, if you're a beneficiary of my trust and for some reason you make me angry, I can now, in a domestic asset protection trust scenario, say, Rick, you're out. That wonderful little son of yours, Dylan, is in. I'd rather give my stuff to him anyway. So say goodbye, Rick. I'm going to put Dylan in there instead of you.
Okay, so you can do that, and that's a great benefit then to what we're talking about here, because
absolutely it is, and you'd rather have Dylan in there anyway, wouldn't you?
Yeah, absolutely. Yeah.
All right. Now, one of the other powers, power number 2, would be trustee. Remember I said when you have a revocable trust, one you can revoke during the course of your lifetime, you can be the trustor, the creator, and you can be the trustee. In an irrevocable trust, normally, you are the trustor only, but you're not the trustee. Now with the domestic asset protection trust, you can be the creator, the trustor, and the trustee again. But here's the catch. You must allocate the powers between trustees. Okay, for example, under a traditional trust, as I just mentioned, you have a single trustee that's responsible for making the distributions, taking care of the administrative matters, the bookkeeping, etc., making sure the investments are in place to make the trust assets grow, all of those things. and you have the trustee who's responsible for distributing assets to various beneficiaries, either during the course of the trust, if the trust says you can do that, or at the end of the trust, when the trust is no longer there, you distribute assets in a final distribution. Here, in a domestic asset protection trust, if you choose states like Nevada, Wyoming, Oklahoma, Delaware, and these are states I would recommend, there you can be a co-trustee. So in other words, what's the beauty of this? The beauty of this is you can now have a trustee who does the administrative work of the trust, located in the state where you establish the trust. Okay, the domestic asset protection trust. Let's take Nevada, for example. You establish a domestic asset protection trust in Nevada. You must have a trustee in the state where the domestic asset protection trust is originated. So you must have a Nevada trustee if you create a domestic asset protection trust in Nevada. However, you who live in California can be a co-trustee, and guess what you can do? You can be in charge of investing all of the assets of the trust, right? Mm-hmm. So now you decide where your investments want to be and how you want to make money for this irrevocable trust, of which you can also be a beneficiary. And that's one of the other big topics that we next come to address, and that's number 3. That's the big 3. I would like to call it. So you can now be a beneficiary. Okay, you can receive distributions from this trust in unique ways that normally you couldn't when you were establishing a regular irrevocable trust that can't be revoked during the course of your lifetime. Now you have an irrevocable trust that's called a domestic asset protection trust, of which you can also be a beneficiary of the trust. So those are the big powers that you have with this unique trust, Rick.
Yeah, that sounds great, because it not only does it gives you the added protection, but it also gives you the flexibility in not so much manipulating the trust, but in the way that you run the trust, correct?
Yes, and importantly, I might want to add to this, being a beneficiary, being a settlor, and also being a beneficiary. The only caveat is that the other trustee will make distributions to you with his approval. In other words, you can receive distributions as a settlor beneficiary, but the other trustee, the co-trustee, must approve any distributions that you get. And that keeps that unique limitation on it to where it balances out to make sure that everything, hopefully is on the up and up. Okay. And that's very, very important.
Did you want to go into the tax implications with this, or have you already mentioned that?
You know what? The tax implications are very, very simple. I would always urge someone to see an accountant about this, but historically, Rick, any income you would receive from this trust is going to be reported on your tax return. Now, are there ways to arrange with your accountant how you take income and how much is going to be taxed at what particular time? Certainly there could be, and that's what you need your accountant for. But my only purpose here for today is to tell you that when you receive anything from this trust, it will be declared income, and you'll have to report it on your tax return in consultation with your accountant.
Okay.
And that's it. And at the end of the show, or toward the end of the show, I'm going to go into some unique discussions about what's called a family LLC and how we roll that into a domestic asset protection trust.
Okay. Well, great. We have about 10 minutes left in the show, but before we get into your discussion about the family LLCs, which we'll talk about after the break, Bill, we have another sponsor that we want to talk about here. Why don't you share with our audience who that is?
Thanks, Rick. I would like to talk about, just very briefly, our sister companion to the Bottle Business Sense show, and that's the Bottle Business Sense newsletter. You can find that at bottledbusinesssense.com. Okay, now the show website is bottlebusinesssenseshow.com. Just take off the word show and bottlebusinessense.com, and you'll come to our website. It has unique articles about asset protection, employment law, estate planning, and some do-it-yourself availability, programs that you might want to do on your own, and also a little bit about my company, WFBLegalConsulting.com. And also some philosophical discussion on different issues that I pick out each month. In any event, if you go to the right-hand margin, you will see on the website it says free and timely business and legal tips to propel your business. Subscribe to WFB Legal Consulting Incorporated's Bottle Business Sense newsletter today. You just fill in your name and your email, you submit it. AWeber will then send you an email saying this is what you signed up for. Are you sure you want it? You simply say yes, and you'll get the free newsletter every month, and it'll a lot of it will talk about different things that perhaps Rick and I have been discussing, but you'll get a lot of unique stuff in there that maybe isn't on the show. So please feel free to sign up for that. It's again totally for free, and it's meant to help you and your business succeed.
Well, that's great. Let's go ahead and start wrapping up the show here. I know you have a little bit more to talk about, Bill, and that is in regards to the family LLC.
Yes. We're talking about a normal LLC, and we're talking about a family LLC, so it's typically referred to then as the FLLC. And how does that fall into our discussion about domestic asset protection trusts? Well, you have a client, and the client creates an LLC. The client then gifts 1/3 membership of that LLC, 1/3 of the value of that LLC to the Domestic Asset Protection Trust. It's a gift to the trust. Now that trust, that irrevocable Domestic Asset Protection Trust, owns 1/3 of the LLC. The client retains control of the LLC as the manager. The client can receive distributions from the other co-trustee with his permission at that trustee's discretion from the business of that LLC. Now, how do we make this even better? Let's say that your wife has a domestic asset protection trust. She now makes a gift of part of the family LLC to her own trust. She now draws an income from that LLC. You're both drawing incomes from the LLC, and now you are the beneficiary of your wife's trust. Your wife is the beneficiary of your trust, and so when one passes, part of that business then comes back out of that irrevocable domestic asset protection trust to the surviving settlor, the creator of his own trust, right? So now you've got two settlors. They have their own trust. They gift a part of the business to that trust. They draw income from that business at the discretion of the co-trustee who decides how much to give you. And you can make each part of that business a asset that will go to your spouse. You can make each of the spouses the beneficiaries of each other's trusts. Pretty awesome, huh, Rick?
That is pretty awesome. It gives you even more added benefits and flexibility in everything that you've explained here. So
I would urge people to see a lawyer. Make sure you see the right person to get your feet wet and to see if this is something that you might want to talk about. And that's where I indicated earlier I would end the show on whether or not, a domestic asset protection trust is right for you. Well, look, this is a powerful tool that can provide protection from creditors while still allowing the settlor or the creator of the trust some benefit and control of the trust assets, which normally he wouldn't have in an irrevocable situation. We've talked about that. They can be appropriate for a wide range of people, but here's what I would normally suggest. Professionals, officers and directors of companies, important fiduciaries, people who have a lot of fiduciary responsibility. That is, people that have special knowledge about a certain subject that other people rely on them for. Attorneys, physicians, accountants. Real estate owners and real estate investors who have large properties, people that have exposure, large legal exposure. They're doing work in businesses, for example, that often get sued just by the nature of the business. One I can think of off the top of my head would be a home in-home care facility. Many times you have employees who are lifting up the elderly who get hurt. And who claim that there's no workers' compensation coverage when there may be, or maybe it's a different type of claim that's not covered under workers' comp. Or you have the people in the home themselves that get injured and they make a claim against you. High liability businesses would fall into that category, or just generally speaking, someone with larger estates. This doesn't mean you can't do it if you have a smaller estate, but you just need to sit down and see if it's right for you. These types of trusts need to be geared for your goals, and you need to find out if the goals of your business and your estate planning warrant the adaptation of such a unique trust. And that's where we've talked for a long time, Rick, about how you need to sit down with your professional and make sure you're pointed in the right direction.
Yeah.
So just make sure, do not do any of this with an attempt to hide assets. Don't do it after a problem arises. Always do it before one is on the horizon.
Absolutely, Bill. And I'm glad you bring that up, because if you want to do this correctly, folks, and you want to plan, prepare, and protect yourself, then what you need to do is contact someone like Bill, or contact Bill directly, and he can start a conversation with you to see if any of these protection offerings are right for you. So, Bill, why don't you take out the show here and tell everyone how to get a hold of you.
Thank you, Rick. Well, again, you can get a hold of me at my website, which is wfblegalconsulting.com. My email for that site is bill@wfblegalconsulting.com. Of course, you can get a hold of me at my phone number, which is 949 area code 413-6535. Also 949-698-6222. And you can email me on Facebook, LinkedIn. I'm on Avo. Please go look at avvo.com. Very important website for lawyers. There you will see on that site my rating. You will see my testimonials from both clients and from other lawyers. I would suggest you look at that if you choose. So that's it in a nutshell, Rick. Before we leave, let's tell our viewers and listeners what next week's show is all about.
Well, great, Bill, and thanks again for all the valuable information that you've shared here with our viewers.
My pleasure. My pleasure.
Again, we're on every Tuesday at 10 o'clock a.m. Pacific time on Blog Talk Radio, or on our simulcast website at bottledbusinessshow.com, 10 o'clock Pacific time. And for next week, Bill and I are going to discuss the reasons why most startups fail. So that's going to be a great show that I know there's going to be a lot of interest in, and I'm excited to talk about that.
I am as well. I think it'll be a great lead-in for people to put their arms around and say, look, I'm thinking about starting a business. I know I need a lawyer. I know I need an accountant. I know I need a marketing guy. And with that said, how do I make sure that my startup doesn't fail? Obviously one of the ingredients of making sure it doesn't fail is having those three people on board, but there's other things that you need to be careful of as well, and that's what we want to talk about next week.
All right. Well, that's great. Well, folks, thanks again for joining us today for this episode of the Bottled Business Sense Show. We will see you again next week, same time, same channel. We'll see you there.
You got it. Take care, everybody.